Right, so this week the Constitutional Court formally separated from the Supreme Court, meaning that what used to be a panel of 9 Supreme Court justices sitting as a Constitutional Court bench will now be a panel of 7 judges who will exclusively be Constitutional Court judges. What we're supposed to expect from this is more specialization, because formerly judges of the Supreme Court were exercising the constitutional jurisdiction, meaning they sat on the 2 top courts in the country, because the Constitutional Court is the highest court in constitutional matters and the Supreme Court is the highest in all other matters. And by formally separating the 2 courts, this will enable judges to be able to concentrate on their constitutional mandate without having to worry about cases brought on appeal in the Supreme Court. I make that point mindful of the fact that the Chief Justice and Deputy Chief Justice both remain members of the Constitutional Court and the Supreme Court. So they do not seem, in terms of the Constitution, subject to the separation, which is distinct from other jurisdictions. In Zambia, the Chief Justice has the Supreme Court, but a president has the Constitutional Court. It doesn't seem like in our framing we wanted that sort of separation, so there's still that sort of unified leadership of both courts, at least in terms of the Constitution. So what that means is that we'll now have a standalone court responsible for constitutional enforcement and litigation. What that is supposed to do is really show a commitment to the rule of law and constitutionalism by having a specialized court with judges that only concentrate on constitutional jurisdiction. More or less, we'll now actually have constitutional judges. Some of you may be aware that the American system, which is where the powers of constitutional jurisdiction originate, have got a diffuse sort of constitutional jurisdiction, in terms of which all the courts, from the lowest to the highest, can strike down a law as unconstitutional without needing to refer to any higher court. But the European variant was different, because the European countries generally were not as trusting of judges as the Americans were. So generally the courts were not given a power to strike down laws as unconstitutional, and constitutional courts were introduced as this one institution at the top of the judiciary, or sometimes actually outside of the judiciary, to which questions of constitutionality were referred, and that one institution made the decisions. And South Africa, after apartheid, more or less continues that tradition. There's constitutional migration, mostly from Germany into South Africa, when they established their constitutional court, and we are more or less following in that same trajectory, where we have that main standalone court at the top. Constitutional questions are referred. Sometimes it has got coordinate jurisdiction with lower courts like the High Court or Supreme Court, but the Constitutional Court is the final say. So in a sense, it's a very centralized form of constitutional jurisdiction, which mirrors in some respects the European system. Is definitely different from the American system. We did not get information on who the acting judges of the Constitutional Court are. It seems we're still waiting for the appointing authority to make the substantive appointments, but going forward, this is a new era for everybody, and what we expect is the fact that constitutional jurisprudence shall flourish, because there are judges who will be able to spend all their time really considering these sort of constitutional matters.